Now, before we start today's session, I would like to briefly outline the vision and the object of the IAF, what it does, how it came into being. I will not take more than 5 minutes for this exercise. Founded in 2013, the IAF is an association of leading arbitration practitioners committed to encouraging best practices in arbitration, streamlining the conduct of arbitration, and promoting arbitration as an effective means of dispute resolution in India and abroad. Broadly, some of its objectives are to promote arbitration as an effective dispute resolution method, engage with government for legislative reform, market India as a venue for arbitration, broaden the base of arbitration from allied industries, including engineers, accountants, surveyors, bankers, and others, collaborate with international societies, institutions, and associations, facilitate collaboration between legal practitioners, companies, industry. Therefore, the intent really is to promote India as a hub for resolving disputes through arbitration in accordance with international standards and at the same time ensuring best practices in arbitration. Notably, the IF is a first of its kind initiative by legal practitioners which seek to establish an arbitration bar in India, not for regulating arbitration practices, but only to encourage best practices in the field of arbitration in India. To that end, the IF devised the best practices guidelines for conduct of arbitral proceedings in partnership with members of COMBAR, the Commercial Bar Association of England and Wales, and in association with Singapore International Arbitration Centre, Mumbai Centre for International Arbitration, and Gujarat National Law University. These guidelines were reviewed by legal luminaries, including Justice B.N. Krishna, Justice A.P. Shah, and a panel comprising of the IAF members as well as other leading practitioners. The guidelines, so framed, sought to keep a balance between international best practices as well as practical realities in the Indian context. Subsequently, the IAF launched its Best Practices Guideline version 2.0 on 2nd May 2020. These are updated guidelines for the conduct of arbitration. Guidelines version 2.0 have incorporated inputs from various eminent jurists, including Honorable Mr. Justice Vibhu Bhakru, who is on the panel today, and Senior Counsel Dr. Virender Saraf, Honorary Secretary, Bombay Bar Association. The guidelines aim to promote for best practices to be followed in arbitration to achieve seamless dispute resolution in a cost and time efficient manner. Some features of these guidelines are incorporation of the red fund schedule for the purpose of disclosure of documents, reference to video conferencing, which has attained impetus during COVID-19, live recording of proceedings, and hot tubbing of experts. The guidelines also envisage the option of adopting soft laws such as IBA rules on taking of evidence in international arbitration and highlight consequences of misconduct by a party, representative, and counsel. The stage is now set for a brief introduction to our esteemed panelists to share their illuminating thoughts. First on the panel is Honorable Mr. Justice Vibhu Bhakru, a sitting judge of Bombay, a sitting judge of Delhi High Court, who has authored several landmark judgments in the field of arbitration, including enforcement of foreign awards. The decision reflected his thorough knowledge of law, forthrightness, and fairest independence. Leading by example as a member of the bench, sir, your wisdom, patience, and equanimity continue to inspire the bar. He has been extremely kind to provide his inputs, which are reflected in the present guidelines version 2.0. Our next panelist is Honorable Mr. Justice Badr Durraiz Ahmed. Justice Ahmed is a former Chief Justice of the Jammu and Kashmir High Court. He has also served as the Acting Chief Justice of the Delhi High Court twice. I will always remember the full court reference which took place for bidding farewell to Justice Ahmed, which witnessed one of the largest gatherings of lawyers in New Delhi. Justice Ahmed has made distinguished and immense contribution towards the development of the Delhi High Court as an institution of justice. He has also been instrumental in introducing the concept of e-filing both at the Delhi High Court and the High Court of Jammu and Kashmir. Justice Badr Ahmed is a renowned figure and has immensely contributed in development of arbitration jurisprudence in India. Finally, we have amongst us Mr. Jasbir Dhillon QC, who has over 25 years of experience specializing in complex and high-value commercial dispute. Jasbir has played an integral role in the development of guidelines and has been involved in many of the leading English commercial cases. Jasbir is recognized by the legal directories as leading barrister in international arbitration. He is regularly instructed to appear as counsel in major international arbitrations under the LCI, ICC, SIAC, and CASTRO. The panel is moderated by my friends Tejas Karya, partner and head arbitration at Shadul Amarchand Mangaldas and Company, and Shashank Garg, partner head of office, Delhi, Advani and Company. Both of them have played an integral role in the development of these guidelines as a member of the IAF team. Without further ado, over to our moderators, Shashank and Tejas.
Thank you, Sumit, and for that kind introduction and to the panelists and the IAF. Welcome all of you to this launch of IAF Guideline version 2.0. We successfully launched these guidelines through a similar webinar conducted through our friends from Mumbai IAF. And now this is from Delhi region. We are trying to launch the same thing. We had a lot of plans to launch it in a big event. But with this situation of COVID, we thought this is the best way to launch the guidelines rather than leaving it for reopening of so that we can meet, all of us can meet and have the launch. So the idea for today's session is, of course, launch and have a panel discussion, and we all have been introduced to the panel. So the first topic we wanted to discuss is that how far we have been able to institutionalize arbitration in India, and what is the stage of institutional arbitration in India. And we have been accustomed to ad hoc arbitrations being run by the arbitral tribunals without any support or supervision from arbitral institutions. And that's where this soft law of IAF guidelines was thought about, and we have come a long way since we conceptualized and launched the first version, and now we have significantly improved second version. So if I can ask Justice Bakru, in your experience, sir, what is the difference between ad hoc and institutional arbitration, and which one would you prefer? And obviously for what reasons that you would prefer ad hoc or institutional? And what are your thoughts about that?
I think this question has been debated and much debated over and over again as to what are the advantages of an institutional arbitration and what are the advantages of an ad hoc arbitration. Well, I think the answers are very clear. As far as institutional arbitrations are concerned, they are administered arbitration. So therefore, there is a set of rules that an institution follows. And this gives very, very strong support to the arbitral proceedings, particularly in the field as far as appointment of arbitrators and the aspect of challenge to their challenge to arbitrators. I think there is really no real answer to have other than an institutional arbitration. And apart from that, there are other advantages. As one of the key areas that I think most institutions are now working in is quality control. It's the quality control of the arbitral award that ultimately comes out. So draft awards are vetted, and in some cases, there are also inputs are given as far as, at least in the manner in which they're written. So there are advantages of, very well accepted advantages of institutional arbitrations. But having said that, one can't write off ad hoc arbitrations altogether. The advantage for an ad hoc arbitration is really the flexibility. So there are some areas where the parties desire a higher degree of flexibility. In those areas, and in those only limited areas, that I think ad hoc arbitration has its value. But, an example that comes to mind straight away is probably like family arbitration, where family disputes are sought to be resolved. Now, you may not be able to put them in particular silos of businesses. The businesses may span over several companies, other organizations. There may be interpersonal relations. So it's possible where the parties feel that they require the flexibility of a known arbitrator, which they are comfortable with, and they control the procedure by and large with the aid of the arbitrator. And it's all fine, because that's let's say, advantage of arbitration in the first place. But so far as my personal opinion is concerned, I think the time has come that we'll have to have shift from ad hoc arbitrations now to institutionalized arbitrations. I mean, all over the world, we have, I mean, there was one report which has been referred to in Justice B.N. Krishna's committee report that did between PricewaterhouseCoopers and Queen Mary University. And they said about 86% of the awards in the last decade were from institutional arbitrations. And 67% were those where state parties were involved. Now, this is quite different from what we have in our country. And one particular seminar, I think it was estimated that almost 80% of the awards come from ad hoc arbitrations and less than 20% come from institutionally administered. Now, I think this will really have to change because the advantages of institutional arbitration are far too many. And I think the institutional arbitration in this country has suffered for various reasons. But one of the predominant reasons is that there has been bulk of the arbitration is with state, and state authorities haven't yet acceded to institutional arbitration in a big way. In fact, if you look at all the arbitration clauses, one thing that runs very clear to it is a desire by one party, the state party, to ensure that they have complete control in appointing the arbitral tribunal, whether it be from their panel, where they give certain officers the right to appoint arbitrators and so on. And this is really militates against one of the fundamental reasons why we have institutional arbitration, and that is the institution then appoints, which is an appointment of arbitration. I think this area has been identified and that is being worked on. The recent trend of judicial decisions that have come from Supreme Court also clearly point to the view that this desire of any one singular party to control the appointment of arbitral tribunal will not really be accepted in any good measure. So that's where we are. And I think with the latest decision, I think in Perkins, I think it was West Plyne first where the Supreme Court said you must have a broad-based panel, and they rejected a restricted panel. It went, I think, then you had TRF and Negro, and then you have Perkins. So now, really, the party's decision to rest to control of the appointment of an arbitral tribunal to one single party now goes. And with this area now possibly being diminished, I think more and more persons would, state authorities and PSUs would probably either accede to arbitration through institutions or not go for arbitration at all. So this is really where I think the line lies. But overall, I think the institutional arbitrations is the way forward. And one would really like to see this percentage reverse. That means 20% by ad hoc arbitration and about 80% by institutional arbitrations. The advantages of an institutional arbitration are far too many to ignore.
Yeah, thank you. It's quite encouraging to say that the way forward is institutional arbitration, and it was quite an interesting perspective. We thought we will run a short poll for our audience to also weigh in what is their preference as far as institutional versus ad hoc. So you can see the screen, you can select one of the options, and we will see the results in few seconds. Oh, that's quite encouraging. 80% of our viewers feel that institutional is most preferred to ad hoc arbitration. That's quite good.
This is in fact very different from the results that we got from the poll that was conducted when the launch event happened in Mumbai. It was 51 for ad hoc and 49 for institutional arbitration. So I am assuming that within a week there has been a transformation, and that our previous event has created that sort of positive impact. Now, moving forward, I would like to ask Justice Ahmed, uh, in your experience now as an arbitrator, also, can you highlight some of the steps that we as India have taken, whether the steps from the judiciary or the legislative amendments to boost India as an institutional arbitration hub, and making the users aware of the institutions that are available and the advantages of it? Would you also consider that the latest bill that was passed in Rajya Sabha but has not been notified, which is the New Delhi International Arbitration Conciliation Amendment Act of 2019, if that comes into effect, which I believe is taking over of ICADR, based in Vasant Kunj, that entire institution will become this New Delhi International Arbitration Center. Do you think this is also a very key step in this regard, or there are other better steps that have been taken in the recent past?
First of all, I think I must say that the poll difference that you had was because of Justice Bhakru's speech. And he had primed them into thinking 80 and 20. So you got the 80 and 20 answer. But he's right. He's right. Most of the arbitrations that take place in India, and I've been a part of it for the last 2 years, I find that we lack administrative backing. And after all, an institutional arbitration is meant to provide that administrative backing. And therefore, I think that institutional arbitration is the way forward. But the fact of the matter is that we do not have those institutions. And we have to develop those institutions. For example, I'll give you an example like the Delhi High Court International Arbitration Center, which was headed by Justice Bhakru for some time. It started off very well, but it has to now take on a greater caseload. And the result is that we are unable to get times, etc. And administering the various litigations is becoming very difficult. So it has to be backed up by a huge infrastructural effort. And unless and until that happens, I don't think that institutional arbitration in India, we may have it on paper, but in practice, we have to build not only the brick and mortar institution, but we also have to put in the manpower and the skill set which is necessary for an institutional arbitration. I've been involved in several institutional arbitrations in ICC, etc., where you see the complete difference is there. I mean, the institution takes over or oversees the entire arbitration process from beginning till the end. And as Justice Bhakru pointed out, your awards are first, draft awards are prepared, then the draft awards are sent to the center, they are looked into, they examine whether any point has been left out, not left out, has been dealt with or not dealt with. And ultimately, then you come across the final award. So that minimizes the chance of awards being set aside by courts and appellate courts, and thereby curtailing the period between which a person who has been granted relief gets the relief. Having said that, insofar as the New Delhi International Arbitration Center is concerned, I thought, that is my personal view, that it was more a takeover of ICDR rather than setting up of an institution as such, although both have been steamrolled into one. Now the question is that that institution has still not come into being. If it comes into being, and when it comes into being, it will have to be not only, it is infrastructurally sound in the sense that there is a building, there are rooms, there are areas where people can assemble and have meetings, but it should not just be a brick and mortar institution. It must be an institution which is alive, in the sense that there are people who can man that institution properly and bring about arbitrations in a very disciplined and timely manner, with all the infrastructural support that is required in the modern day world. And as long as that happens, that does not happen, I don't think, although we may want institutional arbitration to take huge strides in India, it will not happen. We have several institutions. We have the Nani Palkiwala institution, we have ICA, we have the Delhi High Court. In fact, many high courts have attached arbitration centers, which are also institutional arbitrations. But none of them have come up to being an institutional hub in India, as is the case of Singapore and other countries, other places. So until and unless we have that huge infrastructural backbone, which in which I include not only the buildings and the machines and all that, but also the people who man that institution, the people who are assigned to a particular case must know how to deal with that case and how to see it through. Each case that is taken up in an institution has somebody has got to own that case. Basically, what I'm trying to say, an institution has to own that case and to see it through and see that the arbitrators are not left in the lurch. So unless and until that happens, I'm not all that optimistic about institutional arbitration taking taking great strides in India in the near future. Although that is the way forward.
So before we move on, just on what you stated, we had a webinar with Justice Sanjay Kaul and Justice Shakdar a couple of weeks ago on the point of appointment of arbitrators. A point that was raised by Justice Kaul, and I would request Justice Ahmed to reflect upon it, because that is the perception in the mindset of a lot of users of arbitration, that arbitrators prefer ad hoc over institutional arbitrations, at least in India, due to the fee regime, because the Indian institutions, for example, DIAC or NPAC, etc., have a much lower fee than what can be charged in an ad hoc arbitration. So if you could reflect upon this perception, whether this is a clear, if it is a correct depiction of how things are happening, or if the arbitrators are happy taking Indian institutional arbitrations also.
See, what I feel is that institutional arbitration may be more expensive for the litigants than ad hoc arbitration, because they have to pay the fees of the institution also, which at times may be quite high. But insofar as the arbitral fees are concerned, I think now things have been quite streamlined in India because of the fourth schedule. The fourth schedule has given a baseline, and that baseline is more or less adhered to. And of course, now they've brought in an amendment which they have not notified as yet, where the central government can amend the fourth schedule by notification rather than going through the parliament route. So that would be necessary, because essentially for reworking the cap that has been put. Because although up to the cap everything is ad valorem, but once the cap is there, then beyond that everything gets stuck. And as you know, as the monetary economy moves ahead, money values change, and therefore you'll have the same litigation involving much higher numbers, and therefore the fees would also have to be altered according to the cap would also have to be altered according to that. So I don't see that arbitrators prefer ad hoc arbitrations because of the fee structure, because fee structure is more or less crystallized by the fourth schedule, which even is being followed by ad hoc arbitrations, although it's not binding on them, but more or less they are following that. And that has been my experience, and I think most arbitrators are happy to go along with the fourth schedule fee structure, except of course in exceptional cases where the claim is for 10,000 crores or something like that. Then of course it becomes a little painful to follow the fourth schedule.
No, that's true, because we have seen that even in ad hoc arbitrations, they're quite comfortable with fourth schedule and going ahead with that, because that's also not too bad a cap on the fees, and it gives some kind of certainty, and which also is quite similar to institutional rules, which brings some certainty in terms of the cost of arbitration. But having said that, it seems that institutional arbitration, although we have embarked the journey, we have long way to go, and ad hoc will remain in our bucket of arbitrations to some extent, although the percentage of ad hoc over a period of time will reduce. But till such time we have ad hoc arbitrations, soft law like IAF guidelines play a very major role in streamlining and trying to conduct the arbitration in a very similar way as if it's an institutional arbitration. And that's where we have these guidelines, which for conduct of arbitration in an ad hoc, most likely in ad hoc, because institutions have their own rules to govern the arbitrations. So if I can ask Mr. Dillon, what are the few highlights or salient features which you would like to highlight in terms of this new version of IAF guidelines? And from your perspectives, seeing the Indian arbitration regime from some distance, of course you're part of that regime and you appear in Indian arbitration very regularly. But how do you see that we all can use this soft law of IAF guidelines, like we use IBA guidelines on taking evidence and otherwise, but what are the main features you feel that someone should keep it in mind so that in the ad hoc arbitration at PO1 itself, we can incorporate IAF guidelines into the PO1 and it becomes part of the process?
Well, first of all, can I thank all of you for inviting me to join this extremely distinguished panel to talk about the guidelines. And I also want to emphasize how much I'd like to commend yourself, Tejas, Shashank, and all of your colleagues in this effort in relation to the guidelines to try and provide some guidance to the Indian arbitral community about improving standards, because I think this is very much an idea whose time has come. And I know we'll come on to this later about how one can improve the communication of the message that's contained, the importance in the guidelines to all Indian practitioners. But I would very much welcome and commend ideas of trying to get the message out as the guidelines are seeking to do. Of course, there are so many features of the guidelines that are aimed at streamlining the conduct of arbitrations. And so all I can do is highlight a couple of significant features, but I would commend all of the viewers and listeners to go to the guidelines themselves and see how many features of it will in my view, streamline the conduct of arbitral proceedings. But the articles that I'd like to highlight are, first of all, Article 8. Article 8 deals with the case management conference, and this provides that the case management conference must be held, and in that case management conference, the tribunal is required to set time limits for each procedural step, including the dates for the hearing, time limits for the written evidence and the submissions to be filed, and subparagraph 6 of Article 8 provides that derogations from those time limits are only permitted with, and this is quite important, the prospective permission of the tribunal. And if one of the parties seeks retrospective permission for the derogation from a time limit, then the tribunal, only if satisfied that the reason for delay is justifiable, can grant it. If the reason for the delay is not justifiable, then the tribunal has to consider if it is in the interests of justice to condone the delay, and it also is given a power to impose costs on the party that is in breach. Now, Article 8 needs to be read in conjunction with Article 36, because the former provision provides that the tribunal generally should not tolerate inordinate delay by the parties, and it defines what is meant by a justifiable reason for delay. So this setting of time limits and exhorting the tribunal and the parties not to depart from that initial program that's set at the case management conference, that is incredibly important, an incredibly important component in terms of ensuring that the arbitral proceedings are conducted and finished without delay. Now, the 64 million rupee question is whether or not tribunals will give permission to depart from those time limits. And if so, what are the terms that the tribunal will impose, whether that will be the payment of costs. Now, of course, ultimately, as with all soft law, while you can exhort parties and tribunals to get on with the tribunal, ultimately, the ease with which the tribunal will grant extensions of time will depend on the tribunal. And every tribunal will have its own attitudes to whether excuses are justifiable or whether they are unjustifiable. And if they're unjustifiable, what sanctions will be applied. Now, I think this raises quite an important issue, which as an outsider, as a non-Indian advocate, I can comment on from the outside, but ultimately only Indian lawyers can determine whether this is a serious problem, and if so, how to resolve it. But it seems to me that there are cultural attitudes, judicial cultural attitudes to delay, which are determined based on your experience of how long proceedings should take, what is an acceptable reason for an extension of time, and what is not a justifiable extension of time. And obviously, it's a matter of record that Indian legal proceedings have had significant problems with delays, and sometimes you see that with arbitral proceedings. None of that is going to change overnight, but what I think this guideline seeks to do is to focus the mind on significant parts of the arbitral process, and the case management conference and the timetable for the procedural steps is a very important part of that process. And it seeks to try and introduce that element of alacrity in the arbitral process, and it will provide support for those parties, those members of tribunals who want to get on with the proceedings, and it can be used against those parties that might be seeking to drag their feet to say, this is not really what we should be doing, we need to be pressing on, and therefore we need to stick to our time limits. So that's what it seeks to do. I'll be very interested to hear what other members of the panel and viewers have to say about that. The second provision I would highlight are Articles 9 and 10, which address the written opening submissions and also the post-hearing written submissions. And what Articles 9 and 10 seek to do, they seek to encourage, and again, the important word here is detailed written submissions, both pre the arbitral hearing and then potentially post the hearing. Now, one problem that I've certainly seen in my very limited experience in Indian arbitration that can lend itself to delay is that some Indian advocates tend to prefer to leave their written submissions to after, or the detailed written submissions to after the hearing. So after all of the evidence has been taken and after the oral submissions have been recorded. Now, it seems to me, having seen that operate in practice on occasion, this is a very inefficient way of going about things, and it's productive of delay, because the oral argument will be much shorter and will be much more efficient if the parties and the tribunal have the benefit of detailed written submissions before you have the oral hearing, because then they will know, well, what is the case that I have to meet? And the tribunal can also interrogate the advocates on an informed basis, knowing what is the case that you are advancing. And then you can have your viva voce or Socratic dialogue in the oral hearing, get to see the weaknesses and get to see the strengths. Now, this guideline seeks to address that problem by emphasizing that it's the pre-hearing written submissions that need to be detailed, and those are the norm, and that the post-hearing written submissions are not the norm and have to be justified if you are going to seek permission to do that, and they should be allowed only in relatively limited circumstances. Again, I'll be very interested to hear what other members of the panel and viewers think about whether that is an important and significant problem, and whether the guideline addresses that, or whether in fact this is not such a big problem and doesn't really produce delay. I think that's all that I wanted to say at this stage on streamlining the arbitral process.
Thank you, Jasbir, for that insight into the guidelines. You've covered quite a few significant articles from the guidelines, and as you've stated, I would also urge all the viewers to have a look at the guidelines, and in case you do not have the benefit of having a copy of the guidelines, they're available on the website of Indian Arbitration Forum. Now I would move on to Justice Bakru. Justice Bakru had the occasion to review these guidelines, and on our request, he sent a detailed review of the first version, and his views were then later on incorporated in this revised version. So we would like to hear from you, your views, whether the IAF guidelines will serve as a useful purpose in filling up the gaps in an ad hoc arbitration and promoting arbitration as an effective means of dispute resolution. And also something that we discussed during the previous event, where Justice Patel expressed his view that these guidelines could be incorporated right at the stage of Section 11 by judicial order. The court can, obviously with the consent of parties, indicate that these guidelines will be used while conducting an ad hoc arbitration. Would that be something that you think is possible at present?
Well, I recollect when this idea of framing guidelines was first mooted, and I think if you recollect that the main object, moving object behind it was to ensure that there is some assistance to the arbitrator, because the problem that number of arbitrators had expressed was, once they're appointed as an arbitrator, they are in an ad hoc arbitration, they are following what really the counsel for the parties tell them. And usually the procedure evolves as and when the arbitration proceedings proceeds. Now, this was of course causing delay. And apart from that, all along the arbitral proceedings, the number of disputes between the parties were multiplying many-fold. Should you have witness action? Should you examine witness orally? Should you accept documents? And in whenever these issues crop up in an arbitration, parties normally are not ad idem. And therefore the idea for framing these guidelines was that once the arbitral tribunal is constituted, or at this stage right from inception, then there is a guideline that an arbitral tribunal can follow. They can draw on these guidelines. I don't think they were meant to be an exhaustive list of rules. It was meant to assist the arbitral tribunal in proceeding further, because there is no procedural law in arbitration. If it comes down to for conducting arbitration, if it's institutional arbitration, of course the institutional rules will take over. But in ad hoc arbitration, unless the parties lay down extensive rules, which almost never happens, it's a very nebulous situation that the arbitral tribunal is left into. So right from, on very small issues, and this is the reason why predominantly ad hoc arbitrations used to get delayed beyond any reasonable period. And that's the idea that these guidelines were meant to address. This is the area that the guidelines were meant to address. And I think to some extent they do it very well, because these guidelines, if one looks carefully, is now an amalgam of not only the procedure, but several concepts and practices that an arbitral tribunal can, with or without the consent of parties, choose to incorporate in the arbitral proceedings. Your evidence action. Now, for example, one goes through it. You have hot tubbing. Now, this is not, at least in India, was not a normal method of. It's not followed in courts. It's certainly not followed in arbitration, that you get more than one expert at one particular point of time, and your evidence is, or your material that comes from them is sort of well debated amongst experts. And this is I think, a very, 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 it's a concept that a practice that one can really evolve and draw a lot of benefit out of. And therefore, these guidelines not only give you the procedure, but also give you some of these little gems and practices that an arbitral tribunal can actually accept. And I think this is why this makes these guidelines valuable in that sense, because I'm sure that over a period of time, arbitral tribunals will draw heavily on these guidelines to, if not counsel for parties may, to push their point as far as their view as far as the procedure is concerned. Now, as far as your second limit, should the courts incorporate it as reference to the rules? Well, I think that militates against the ad hoc arbitration, principles of ad hoc arbitration in the first place. The parties must have their autonomy as how the procedure will proceed further. So unless they agree, and they may not agree to all the guidelines in total, they may have their alternatives here in the guidelines itself, if you look at it, about how an arbitral tribunal can proceed. So they may choose to draw on it as to the extent that they feel necessary, and to the extent the arbitral tribunal feels necessary. So it may not essentially be that fruitful to impose it at the time of appointing an arbitrator and say that you must follow these guidelines. But having said that, if over a period of time, certain procedure gets well accepted, and these guidelines get well accepted in ad hoc arbitration, at that stage, while an arbitral tribunal is being appointed, the parties may consent to incorporate this as a procedure, and therefore avoid protracted arguments and hearings on certain issues which could be addressed merely by following these guidelines.
So that's true. A lot of work has gone into preparing these guidelines, and we have taken the feedback from all the practitioners, judges, and arbitrators to make these guidelines. But the one challenge which we always are going to face is that it's not binding. It's a soft law, and at the end of the day, it may not be binding unless both parties agree. So it really depends on the party autonomy and the arbitrators, and the more and more we, as you rightly said, more and more we use these guidelines, it will become more prevalent, and we can try to imbibe that or incorporate it into the procedural order. Maybe if parties are not agreeing to some bit of it, they can exclude it, like what we do with IBA guidelines. So if I can ask Justice Ahmed, as an arbitrator, as you see now, sir, how can you encourage the use of this IAF guidelines, and what IAF should do to promote these guidelines so that it becomes like a norm, as Justice Bakru suggests? Because the challenge always will be that it's not binding, and how can we make it known to everybody that it becomes prevalent in all ad hoc arbitrations?
Yeah. First of all, I'd like to address the question of whether the court, while appointing the arbitrator, can incorporate these guidelines. I don't think that will be legally possible, because under Section 11, the court is only directed or empowered to appoint an arbitrator and not do anything more. So there Justice Bakru is right when he says that, and I would not agree with Justice Patel if he says that it could be incorporated. Now coming to the main question as to how do we deal with these guidelines and how do we make them prevalent. You see, I've gone through these guidelines, and I find that 90% of it would have no difficulty in being accepted by arbitrators. And although you call it soft law, after all, the procedure of an arbitration is determined by the arbitrator, and of course with the consent of the parties. And I found in my experience that when we set down the first procedural order, in fact, I give detailed steps for procedure and timelines and all these things, nobody objects to it. And in fact, they all fall in line. So if you have arbitrators accepting this as a framework or a backbone on which they can frame their procedural orders, I think a lot of it will get incorporated into the arbitral proceeding itself. And I don't think any lawyer is going to object to procedures which are just and fair to both sides. After all, arbitration and parties who seek arbitration are only there to seek a fair and just decision. And if counsel feel and the parties feel that these points are going to take them towards that objective, they are not going to object. And in fact, there are so many conditions that we stipulate while setting down the first procedural order, and then subsequently when we frame issues and set down the timelines for evidence and timelines for oral arguments. Lawyers don't object at all. And to be fair to everybody, I think the parties also don't object, as long as they see that the arbitration is proceeding on fair lines without any bias. Of course, once they smell bias in an arbitration proceeding, then everything goes haywire. And that happens sometimes. Everything goes haywire. But otherwise, in almost 99% of the cases, at least I have not experienced anybody challenging any of the guidelines or procedural directions that the arbitrator gives, or whether it's a single sole member arbitration or it's a 3-member arbitration. I see no difficulty. So one way I think that you all can ensure that these guidelines get adopted in some form or the other is by circulating it widely amongst all the arbitrators and all the counsel who are in arbitration practice, so that both the counsel as well as the arbitrators are aware of these guidelines, and in fact they incorporate them in their own procedural directions. And once that happens, then it's as good as an institutional arbitration, except that we don't have the administrative backup.
Thank you, sir. I would like to now ask Mr. Dillon, although you have already highlighted a lot of articles from the IAF guidelines, the recent version, but
Shashank, can I just add something before you go to
yes,
Dillon?
Yes, sir.
Because he had made certain submissions or statements with regard to written submissions. And I think this is the opportune time to deal with it before we move on to the next subject of technology and all that. So I think that he is absolutely right that pre-hearing written submissions are more valuable than post-hearing submissions. Because in my experience, what I find is that when lawyers argue with written submissions already before the arbitrators, and the arbitrators having gone through those written submissions, there is brevity in their oral arguments, and there is more precision in their oral arguments. But if you have oral arguments without anything documented, except your pleadings and your oral evidence, etc., then oral arguments can take very tangential routes, and that may expand the time of hearing that is granted to them. Furthermore, if you permit written submissions, detailed written submissions after arguments, then those written submissions can go into hundreds of pages, and most of it may not have been even argued. So it becomes a huge problem for the arbitrators to sift out what has been argued and what has not been argued. And the time of I tell you, the most difficult part of an arbitrator is when he sits down to write the award. In fact, that is the most taxing part of the entire arbitration proceeding. And actually 60% of the time should be devoted to writing that award, whereas it's just the other way around. Because all arbitrations are highly factual, and complex arbitrations involving huge building contracts or construction contracts, railway contracts, and particularly in issues where delays are involved, are very, very complex. And also in financial transactions, there are huge complexities, and we really have to struggle through the facts when you allow counsel to give written submissions after the hearings, which are not argued before you. And that becomes a huge problem. And Justice Bakru will recall that when we were sitting together in the High Court, we used to allow written submissions not exceeding 2 pages, containing the propositions after hearing, for the precise reasoning that you do not have a carte blanche to go and to hundreds and hundreds of pages of written submissions, and you are left with the baby. You can't do anything about it. So I totally agree with Mr. Dillon that pre-hearing written submissions should be the more important one. Post-hearing written submissions should be permitted, but only on certain propositions and very brief. That is what I wanted to add.
So moving on to Mr. Dillon. Mr. Dillon, could you highlight a few international best practices that we could adopt and are already reflected in the IAF guidelines with respect to use of technology?
Thank you, Shashank. I mean, like the answer to the first question, there are so many best practices that are identified in the guidelines that you could sort of almost list most of them and say, well, this is international best practice, and it would be helpful to adopt those in India. And so the references that I made in answer to the first question, the CMC procedural time limit and timetables, and the articles concerning written opening and closing submissions, those are all part of international best practice that have been helpfully adopted in the guidelines. But just to highlight two more best practices that we commonly see in international arbitral practice, which I think will be helpful in if it were adopted in Indian practice as per the guidelines. The first is Article 5.1 of the guidelines provides that the parties and the tribunal shall ensure that the tribunal is able to commit sufficient time to the arbitration. That's always important. But secondly, and is willing to adjudicate the matter during business hours in order to resolve the dispute in timely manner. Now, it's very easy to skirt over that and just sort of assume, well, that's what always happens in India, so what's the problem? But the ability for a tribunal to sit in accordance with what we would do in international arbitration, which would be to sit from 10 a.m. in the morning to 4:30 p.m. at the end of the day, with a 1-hour break for lunch, and to sit for the number of days that is required to hear all of the oral evidence from the factual witnesses, hear all of the evidence from the expert witnesses, and hear opening oral submissions and then closing oral submissions, is not, in my view, necessarily common practice in India. And my, again, very limited experience is that tribunals are sometimes unwilling, and often Indian advocates are unwilling to sit in normal business hours and consecutively for reasons that I'm sure all of the audience are well aware, because of commitments of advocates to their court-based practices. But the problem for the parties in an international arbitration, and that's what we're concerned with here, not the financial or professional concerns of lawyers, is that the problem then is that that leads to delay, because arbitration hearings can't be completed in consecutive days, because they have to be broken up over many weeks and often many months and possibly even years, because sittings have to be conducted in evenings or have to be conducted on weekends. But this also has another problem. It's not just delay. It also leads to problems in the... And of course, quality, if the advocacy is not of the highest quality, then the tribunal, as Mr. Justice Ahmed said, the tribunal, who has the most significant responsibility of drafting the award, if they don't get the highest quality advocacy and assistance with drafting the award, there is every possibility that the quality of the award will not be as good as it would be if they had the highest quality of hearings and submissions, because advocates who don't have sufficient time to prepare for a hearing because they're busy in court during the day or during the week and squeeze in hearings in evenings or weekends, the quality of those submissions are not going to be the same as if you dedicate 2 weeks before the hearing to prepare for a hearing that is going to last 1 week. And in the types of complex international arbitration that I'm involved in, it will be absolutely impossible for me to rock up to an arbitration hearing having been in court on another matter during the day. It just would be absolutely impossible for me to give the quality of cross-examination, presentation of evidence, and presentation of oral and written submissions that my tribunals expect from an advocate. So strict adherence to that guideline, even if you forget some of the other guidelines, seems to me to be bound to improve the delays and also bound to improve the quality and efficiency of the advocacy. And ultimately, the parties who have to pay for all of this process, they, I would have thought, will be pleased that they're having more efficient arbitrations, ultimately having to pay less than they would otherwise have to pay for their lawyers and employees to attend arbitration, and then having higher quality awards. I would have thought all tribunal members would welcome well-prepared advocates efficiently presenting their arguments rather than the contrary. The other thing I just want to touch on, because I think Mr. Justice Ahmed touched on this himself, or I may have misremembered it, it was Justice Barkrew, but the topic of hot tubbing of experts. That again often can work. It's not a method of dealing with experts that's always the right course, but it can work well. But this is an area where it's not so much the advocates that need to be at the forefront of pushing that as a possibility. This is an area where you absolutely have to have, for it to be effective, an active tribunal that is on top of all of the issues, on top of the expert material, in order to make that effective, because the hot tubbing is ultimately for the benefit of the tribunal. If you have a passive tribunal, if the parties decide that hot tubbing is something that we think will be helpful, but you have a passive tribunal that is effectively refereeing the process of recording the evidence and then passively hearing the submissions until it then subsequently gets down to the hard work of getting into the detail for the purpose of drafting the award, in that scenario, hot tubbing will be impossible. And so again, you know, whether that works in terms of financially incentivizing tribunals to get on top of the detail for every arbitration in such a way that they can make hot tubbing work, because they have to be in charge of that process, that will have to remain to be seen.
Thanks. Before we move on to further discussion on use of technology, which is no more just a luxury, I think it has become a necessity in today's time. We have also put a poll on use of technology. If I can request the backend to put that poll. So 77% people feel that now arbitrations can be conducted online, and 23% still feel that there are reservations.
So that's a good number, because we just had an arbitration before this webinar before Justice Ahmed, and it was conducted through online system. And the next date is now in August, and Justice Ahmed again said that it will do it through video conferencing. So now it means that we are moving from real hearings or physical hearings to virtual hearings. So I wanted to quickly ask Justice Ahmed your experience with technology and how technology can change the way we do arbitrations. Of course, you introduced technology to the court system, and we have conducted arbitrations. We carry bags and bags of file, and you carry only one laptop. And you are more efficient in searching the page before even we can search on physical file. So how you have used technology? What are the things like live transcripts, video conferencing, live translation, all such kind of technology can reduce time and cost in terms of arbitration, and you have been using it personally. So what is your recommendation for us for use of technology to streamline the arbitration process?
I think that while having virtual court hearings, maybe somewhat in the distant future for all courts functioning together, but insofar as arbitrations are concerned, it is actually the past. It should be there. It should have already been there. For the present, we can certainly take it up immediately without any difficulty, because after all, we are having a conversation right now, and it's just basically conducting a hearing. And you can share screen, you can transfer documents, you can highlight them, you can present a PowerPoint presentation. Everything is possible. So I'm a great votary for use of technology. Of course, the technology should not become the master. You should continue to remain the master. But the use of technology is essential, and it is not only going to cut a lot of time, but it's also going to cut a lot of costs. For example, if a lawyer is in Bombay, he has a case in Delhi, he need not travel to Delhi. He can argue from Bombay. The arbitration, of course, there will be issues of where is the venue, if the arbitrators are separated, where is the seat of arbitration. Those are issues. Those issues can be sorted out by procedural orders. There's no difficulty on that. But the fact remains that technology is available for conducting an online arbitral hearing without any difficulty, insofar as I'm concerned. People who have been used to appearing before me as an arbitrator know that I only require electronic filing. I don't have paper filing at all. So I don't carry any papers. I use only electronic documents. And of late, I have started signing awards with digital signatures and not with the pen alone. So you don't need paper at all, except for the stamp that you require. Of course, that of course the parties will have to pay for it. But insofar as technology is concerned, there are very simple steps to be taken. Most people who are familiar with the Delhi High Court and most people who are familiar with electronic filing in the Delhi High Court will have absolutely no difficulty. The paper files are converted into electronic files. They are usually in PDF format, and that is the way in which it is filed before the arbitral tribunal. That is the way in which it is served on the other side. And in fact, even cross-examination of witnesses, if necessary, can be done online. And I have done that on several occasions where the witnesses have been moved out of the company and are no longer involved in the company which is involved in the litigation, but a request has been made to them to testify. So they are in some far off place, maybe in Mumbai or in Chennai. So we hook up a teleconference and video conference, and we take evidence on that. So that should not pose any difficulty. The only thing that in India we don't have is a live transcript, which is, we have done it in some cases, but it's, according to many lawyers and litigants, it's very expensive. So I think it has to be popularized, because that's a great time saver. Because every word that the counsel says, every word that the other side says is recorded, every word that the arbitral tribunal says is recorded, and at the end of the day, when you sit down to write the award, the entire transcript is available. And because of live transcription, another benefit is that there is no duplication or repetition, because counsel are aware that it is being recorded. And of course, similarly for the tribunal also, there are no useless remarks, and everything is done in a very professional manner. So I think the time is right for adopting technology in arbitrations, and it is very useful. It has no difficulty, because arbitrations are fixed on time, that you have time slots are given for arbitration, unlike court cases in India at least, where you still have a sequential system of going through the list. Whereas in arbitration, there are exact time slots given, so there should be absolutely no difficulty, and I'm a great votary for it. If there's any difficulty anybody has, I'm always available to help on that score.
Thank you. We have seen that. We have appeared before you, so we know exactly what you are talking, and that's the way to conduct arbitration. We have been trying to tell this to everyone and trying to follow your suggestions.
Any specific question on technology I can answer?
Not really. Wanted to ask Justice Bakru is that do you see any challenges in terms of using technology and that whether it could be a roadblock in terms of arbitration process?
Also, if sir, both of you could highlight how evidentiary hearings could take place by doing them online, how safe it is to do cross-examination and examination of chief of the witnesses online.
Want me to answer? You want me to answer?
Uh,
So either of you.
Vibhu, will you take it or should I take it?
Yeah, I'll take it, sir.
Okay.
See, as far as technology challenges to technology are concerned, there are several. I think the biggest challenge that we face is bandwidth. Although we're conducting court hearings on computer, we find that several of the advocates can't join in, and they have difficulty in joining in, and that's largely because of the bandwidth of signal. So we really need to strengthen our the bandwidth as far as availability of bandwidth is concerned. Otherwise, going beyond this level really is not possible, and I think that's the biggest challenge that we face. Otherwise, if we are able to overcome that challenge in the sense that sufficient bandwidth is made available, then there should not be any difficulty. And the challenge is so acute. I mean, I can give you an example. We had a hearing a couple of days ago, and the advocate who was appearing, he couldn't get the signal. So he went around with his laptop all over his house to try and get the signal. And the video feed was coming through. So we ended up seeing all over his house, but we couldn't hear him. So this is one of the, so we knew his kitchen, we knew his each room, but we couldn't hear him. Now this is really one of the biggest challenges. As far as the second question is concerned, whether we can record evidence, examination in chief and cross-examination in chief by video conference, I think absolutely, provided we have certain checks and balances to ensure that the witness is isolated. There's nobody in that particular room who's prompting him. The material available before him is exactly the material that's available with the arbitral tribunal or with the parties. And I think that can easily be achieved. That's not something very difficult. And then of course is once the recording of the transcript, recording of the entire examination also removes any requirement for the witness to sign off or for any of the counsels to sign off. Once the recording is there, sufficient evidence. So I don't think there is any issue in recording of evidence through e-conferencing or through online.
Yeah, so we are conscious of time and we are just nearing the end of this panel discussion. But if I can ask a very quick question to Mr. Dillon, is that do you see that there is a need to have a separate rules for conducting the arbitration through video conferencing, or we can incorporate certain procedural safeguards by way of best practices which we can incorporate into maybe say next version of our guidelines, or we can come up with a separate rules for conducting arbitration through video conference? In your experience, have you come across such kind of difficulties, and what's your experience has been from UK?
Well, I don't think, apart from Article 29 addresses the question of whether witnesses can be cross-examined by video conferencing, and it sets up an ability to do so, but only in exceptional circumstances. And I think what's clear from the discussion so far by the learned justices is that given current circumstances and probably what's going to happen thereafter, you'll need to get rid of the requirement for there to be exceptional circumstances, because for many hearings, it's perfectly satisfactory, especially when you don't have witnesses, to conduct them via video conference. There is, certainly in the English courts, there have been a slew of guidance given for advocates as to how to adapt the advocacy for the purpose of video hearings, because it's not exactly the same as an in-person hearing. But I think it's very much questions of guidance, because in England, there is no need to adapt the procedure. Everything happens as if you were in court. The only difference is you are at home, but you are effectively in court on the video. So if a witness had someone coaching them in the room, which you couldn't see, I mean, it'd be rather difficult. You wouldn't be able to, obviously you could hear if the witness was being coached, but if someone was sliding pieces of paper and they were looking down, I don't think it would take very long for an opponent to object. And if it turned out on investigation, that would be contempt of court in the same way that, and perjury in the same way that it would be if you're in court. But I think that just a couple of things I just wanted to touch on, which flowed from, again, the wonderful insights from Justice Ahmed. And that is to focus on the issue of transcription of evidence, because based on my very limited experience of observing Indian arbitration, it seems to me that is an absolutely massive opportunity to save costs and delay in Indian arbitration. It's only when you come from my experience where every single hearing is transcribed, and it just, you don't even think about it, it will be transcribed. And then you come to a system where someone is typing by hand what is being recorded, and you see the massive difference. Now, I appreciate that not every case will be able to justify the extra costs of a transcription of the proceedings and the evidence. But I would have thought, and I'm just throwing this figure out there, but any case worth, in terms of the value in the case, of the equivalent of, say, $1 million or maybe less, $500,000, seems to me that it would justify the extra costs of having a professional transcript writer who transcribes the proceedings. It's very important to distinguish between the different types of transcripts. Justice Ahmed referred to live transcript. The technology is such that there are different forms of transcription, each of which have different costs. The most basic transcription, and which is effectively the cheapest, is where the proceedings will be transcribed as live by a professional transcript writer, and that leads to a service where at the end of the court day, so it might be 6:30, 7 p.m. in the evening, you will then get a record, a transcription of the entire day's proceedings. But prior to 7 o'clock, you won't see the transcription. What's called Live Note is a live transcription process, which is much more expensive, but which actually gives you the ability to see the transcript appear on another laptop as you are progressing. So you can literally see the question you asked and the answer given. Now, it's not absolutely essential to have live transcription. We can all hear what is being said in terms of the question. We can all hear what is said in terms of the answer, but it's helpful overnight to be able to read what was said to feed into what happens the next day and for closing submissions. But I would thoroughly commend all practitioners to approach their clients and seek to persuade them to pay for the additional cost of transcription. And I would say this, when you come to the question of cost, I don't know off the top of my head how much it costs to get a professional transcript writer, but I would have thought it will be measured in something in the hundreds of pounds, a day, maybe £500, maybe £600 or £700 a day for a transcript writer. I may have those figures wrong, but the saving, in my view, of having a transcript writer rather than a manual typist it seems to me you will shorten proceedings in terms of the oral evidence of witnesses and cross-examination by at least 3 times and probably upwards of 4 or 5 times. So if you have witnesses who are giving evidence, let's say for 10 days on the basis of the sort of old-fashioned typing method, it seems to me you could quite easily have all of that evidence taken in 3 full days. And you only have to just then factor in if a whole team of lawyers at the marvelous rates that some distinguished Indian advocates can charge, they can only charge 3 days instead of 10, I would have thought, or 12, I would have thought that whatever modest fees, that relatively modest fees that transcript writers charge, whether they have to be flown in initially from Singapore or London or wherever, but I'm sure India is able, with all of its ingenuity, to train up professional transcript writers and have your own homegrown transcript writers. I think that would be a massive boon, not only for the transcript writing profession, but also for arbitral tribunals and for the parties.
Thank you. No, so thank you so much to all of our panelists for such a great insight into all these issues which we have been discussing. So that brings us to the end of the panel discussion, and we have some time left, although we have overshot the time, but we're getting a lot of questions. We may not be able to take all of them, but a few questions. So the first question is for Justice Bakru. Is that we have now Arbitration Council of India in 2019 amendments, and talking about institutional arbitration. But states, it is heavily dominated by the government on that. So what is your view vis-a-vis the institutional arbitration and role of state in governing the arbitration institutions or grading them? Would you be comfortable answering that question?
Well, I'm speaking for myself. My personal view is really that the state control over an arbitral proceeding should be, or an arbitration should be minimal. But as far as this 2019 Amendment Act is concerned, it's essential to examine why that act was enacted. The V.N. Sri Krishna report, which was submitted, had pointed out certain reasons why institutional arbitration in this country had not taken off. And one of the reasons which was highlighted was that there is no infrastructure. None of the institutions have the kind of infrastructure that is required to promote institutional arbitration. And this is a point that was very well highlighted by Justice Ahmed also in this a few minutes ago. Now, who is going to really make that investment? And since that investment is needed and there is really nobody who is forthcoming to make that investment straight away, it's for that reason that the state has, I think, stepped in and said at least some of the arbitral institutions are concerned, they will then fund it and create an infrastructure that is necessary. And I think at this stage, this is necessary. An investment into institutional arbitration is necessary, and there is at this stage nobody who is really forthcoming apart from this state. And I think the state's role in, although a state should not have much role in controlling institutions that control arbitration, but the fact that you require the kind of investment and there's nobody really who can make that investment at this stage, it is inevitable. It's necessary. It's one of the. It's not out of possible states' desire to get into arbitration, but possibly because it is necessary for them to do so.
Sure. So I think we do not have time to take all the questions. So the last question that I would like to ask is to Justice Ahmed. Sir, we have often seen, and since IAF guidelines are soft law, if there are any consequences provided in the soft law, for example, if we take Article 18 of the IAF guidelines, which says that if there is any delay in document production, then it would be subject to monetary sanctions. We've also seen institution rules also, taking example of DIAC rules, adjournment comes with a cost. But very often we have seen that the arbitrators are very lenient, and they, in spite of the rules using the word shall, are usually giving liberty to the party and leave it to the party with warnings, etc. So do you think the consequences and penalties provided in soft law should be adhered to in order to make them more relevant, or should it be an arbitrator's call, even if the soft law, which has been adopted right through the beginning, provides for a mandatory penalty?
I think that if a party or a counsel representing the party is purposely delaying the proceedings and has no reasonable cause, as the expression is used, or justifiable cause, cost should be imposed, because the other party is put to costs. And even in ad hoc arbitrations, we do impose costs. It's not that we don't impose costs, and costs are paid. Now, insofar as the DIAC is concerned, it is mandatory, and I think all arbitrators should follow it, because there is no way out of it. And I have imposed costs even in DIAC proceedings, depending entirely on the schedule. They have a specific schedule which is quite strict, actually, if you look at it, and the parties have to pay up. So that is one way of ensuring that your timelines are met. But what do you do when a situation like COVID-19 lands up? You can't impose costs. That's these are exceptional circumstances, of course, but in normal times, if a party is seen to be delaying a proceeding, he should be saddled with costs, and costs should also reflect actual costs. Sometimes it so happens that everybody is ready from the other side, lawyers have been prepared, everything has come, and suddenly the person says, I'm not well, or I can't argue, or so-and-so has not been able to come. I mean, that is inexcusable. So in those situations, I think you must pay actual costs.
Yeah, that's always, we have seen that actual cost also changes the behavior of parties, and
It does.
there is an actual cost, we have seen many things falling in place without even asking for certain things. But with that, we are all conscious that it has been a great discussion, and we need to put a close to this discussion. So may I request Suruchi to just make some remarks and summarize today's discussion. Over to you, Suruchi. Suruchi, you have to unmute your mic.
Can you hear me now?
Yes.
Yes.
Good evening, everyone. On behalf of the Indian Arbitration Forum, I thank our panelists, Honorable Mr. Justice Bakru, Mr. Former Chief Justice, Justice B.D. Ahmed, Mr. Jasbir Dhillon, our moderators, Mr. Tejas Karya, Shashank Garg, Sumit, who is also on the panel here. Thank you very much. Just to conclude today's panel discussion, I'll sum up very briefly. Justice Bakru had observed that international arbitration provides immense support. We note Justice Ahmed's vision for institutional arbitration in India and his observations on fees. But till we have ad hoc arbitrations, there is a need for guidelines. Mr. Dhillon discussed certain articles of the guidelines, particularly 8, 9, and 36. We note that the guidelines will help parties move on with the arbitration, so that observation is well taken, Mr. Dhillon. Written submissions before the oral hearing would be detailed, and post-hearing submissions should be allowed in exceptional cases and on very brief issues. Justice Bakru has clarified that the guidelines would provide the procedure and conceptual understanding for a tribunal. We hope tribunals and councils will adopt the guidelines. Parties may in time consent to adopt the guidelines. As Mr. Kaya stated, the need is to make the guidelines prevalent. We thank the honorable judges on the panel for reminding us that party autonomy is at the heart of arbitration, and courts may not be able to direct adoption of the guidelines. We thank Justice Ahmed's, we note Justice Ahmed's suggestion to circulate the guidelines to arbitrators and arbitration council, and I'm sure the IAF will take steps in this regard. Mr. Dhillon, we note arbitrations should be a regular business hour affair, and better prepared advocates would lead to better awards. Mr. Dillon has also discussed the concept of hot tubbing briefly. On use of technology to streamline the arbitration process, Justice Ahmed spoke of time and cost benefits, and that live transcription is a great time saver. Justice Bhakru spoke of a stronger bandwidth to counter technology challenges. Isolation of the witness, material available to the witness are measures that one can look out for when looking at online recording of evidence. Mr. Dillon also discussed live and transcription available at the end of the day and benefits in terms of time. Thank you for taking questions, and I thank everybody who has joined in to take benefit of this panel discussion. Have a nice evening, and we will see you at our next event. Many thanks to Indian Arbitration Forum and all you panelists for having joined us today.
Thank you.
Thank you. Thank you, everyone.
Thank you.